There is another way in which the employer could be held responsible for a sexual harassment complaint by civil action under the Ontario Human Rights Code, and that is if there is a poisoned work environment. So the basic principles are the employer in Ontario in a sexual harassment case is not responsible for the conduct of its employees unless there is an argument of the controlling mind, which we discussed in the last video, or alternatively, there is a poisoned work environment. So what's a poisoned work environment? So to create that argument, one would have to show that the company has failed to take reasonable steps to correct an atmosphere of hostility or ongoing sexual harassment conduct that is evident to it or should be evident to it. And if the employer did not do so, then it would be responsible under this concept of a poisoned work environment. And this is likely will be the case if the employer knew of past complaints against Mr. Stronach, or anyone else for that matter, and took no steps to make sure the workplace was safe. Now, I don't know what happened in this example, but judging by reports in the media, which you should probably not rely upon, there may have been other complaints made in the past. And if there was a pattern of complaints, particularly against one person, and the company did nothing to correct it, then there's a very good argument of a poisoned work environment. So again, this is the beauty of the Ontario process, where by civil action, which allows for an expanded limitation period, in fact, no limitation period in this example, and also incorporates the human rights concepts that allows a judge in civil court basically to enforce the human rights code in a courtroom as opposed to an administrative tribunal. So this is a very important feature. This example, I'm not saying there are ongoing cases like this, but if there were, it's a good example of a case in which the employer would be held responsible for this poisoned work environment concept. So be smart and beware.